great. So I will just start. Just before we start, real quick, my name is Anabel Peiro. I'm a legal consultant at Corvers, and we are supporting Teresa PCP when it comes to the actual implementation of the pre-commercial procurement. Also, before start, I would really like to thank you all for your interest in Teresa PCP and for your participation in these open market consultation events. We really appreciate it. In this part of the presentation, what I want to do is to give you a brief introduction to what pre-commercial procurement is, so what Teresa PCP is all about, and its legal framework. I'm saying small, short presentation because this was already presented in several events before. So if you are interested in this and you have more questions, I would highly encourage you to check that presentation. You can, of course, also ask questions in the chat, but this part of the presentation is going to be a bit short because I really want to focus on the intellectual property rights allocation, a key aspect in a pre-commercial procurement, and then on confidentiality issues. So without further ado, let me just jump right into the pre-commercial procurement and its legal framework so that we understand what we are all talking about. What is a pre-commercial procurement? Well, in a pre-commercial procurement, what happens is that we have several public buyers, in this particular case because it's a joint procurement, that have a common need. And when they go to the market to buy a solution to address that need, they realize that the market still has no answer. There is still no solution. So the mindset changes, and what we decide we need is to buy R&D services, research and development services, to develop that solution that we need. That's a pre-commercial procurement. How does this work in practice? Well, in practice, we have a competitive phased approach, which means that, and now I am bringing it back to Teresa pre-commercial procurement, in the first, we are going to divide this procurement in different phases, and these phases are closely linked to the technology readiness level of the solution. Quick disclaimer, technology readiness level is a scale that indicates the maturity of the solution, right? So the lower the technology readiness level, the more R&D is necessary for the solution to make it to the market. And conversely, if you see a high technology readiness level, 8, for example, it means that the solution is really close to the market and just might need minor adaptation. Tier L9 implies that the solution is already widespread on the market. This is just in very simple terms, okay, just for us to understand. So in Teresa PCP, what we will have is a phase 1 in which we will invite several competitors, ideally 5, and we will have these 5 contractors designing a solution. Once this phase is over, the successful ones, the ones that develop, that design a promising solution, will be invited to submit a proposal for phase 2. And then 3 of them, 3 contractors, will be selected to develop a prototype based on their solution design. As you can see here, we are decreasing the number of competitors in each of the phases, and we are increasing the technology readiness level of the solution as the phases progress. Phase 3, same idea. Best contractors from phase 2 will be invited to submit a proposal for phase 3, and 2 selected ones will actually test the prototype that they developed in phase 2 in a real-life environment, in particular in 4 hospitals. At the end of this phase, we will have a working prototype. As you can see, the technology readiness level is very high, which means that the solution is really close to the market. Here, pre-commercial procurement stops, right? So Teresa PCP will stop once we have a working prototype. And if we want to purchase commercial volumes of the solution, then we will need to launch another procurement procedure. Normally, this is done under a public procurement of innovative solutions approach, but that's after the pre-commercial procurement. It doesn't affect us now, okay? Another very, very important characteristic and the goal of today's presentation is the risk-benefits sharing approach. This sounds very fancy, but what does this mean? Well, in practice, this means that in a pre-commercial procurement, the contractors, you as contractors, will be keeping the ownership of the intellectual property rights of the solution that you develop. And in exchange of a lower price paid, because of course we are not keeping the intellectual property rights, the public buyers receive a license to use the solution up until the point it was developed. Let me dwell into that in the next part of the presentation. What do I mean when I am saying that contractors keep the ownership of the intellectual property right? Well, it means that, of course, if you're using background intellectual property rights, that belongs to you, no questions asked about that. The intellectual property rights that are linked to the solution that you developed will also belong to you, which in practice means that once the PCP is over, you can keep further developing it because it's yours. Of course, having this right, having this property comes with certain obligations. You have to inform us of results that can be protected, of the measures that you are taking to protect them, because you are mandated to protect those rights. You also have a mandatory obligation to commercialize. This is all duly explained in the tender documents, just for you to know, explaining also for how long. So normally, for example, the commercialization obligation is for 4 years, because we think that 4 years is a reasonable period for you to commercialize. Same for protection. So you have to inform us in 30 days. And in 30 days, we can have discussions on how you're going to do that, how is it going to be, etc., etc. This is very important because, as I was saying, the public buyers have a right to use the solution. So, of course, we are invested in this and we are interested that these results are protected. If for whichever reason it is you decide not to protect them or not to commercialize, the public buyers have a right to ask you why not. To have a discussion about it, and then they have also a right to protect the intellectual property rights themselves for themselves and to further commercialize the solution for themselves or using a third party. Of course, if you are conducting everything that you can in order to commercialize, for example, but for whichever reason it doesn't work, this can be discussed, okay? It's not written in stone, but the idea is that you do commercialize. Very important, because we are always asked. Public buyers have a right to use the solution up until the point it was developed during the pre-commercial procurement, meaning that we have a right to use the solution up until the point you make it in the PCP. If you made it until PCP phase 2, that's where our rights stop. If you made it until PCP phase 3, that's where our rights stop. If we want to purchase commercial volumes of the solution, that's a whole another story, and we have to discuss then the intellectual property rights. You will keep them, and then we will have to pay a price. Just for you to know, okay? We do have a specific right, which is the right to ask you to give licenses, non-exclusive licenses, to third parties. But these licenses are not for free. They are under fair, reasonable, and non-discriminatory conditions, meaning that you have the right to negotiate. And also important for you to know, the license that you are giving the public buyers group during the PCP is irrevocable, royalty-free, non-exclusive, non-commercial, okay? So just for you to understand. Also, if you don't understand something about this because it's complex, ask as many questions as you want in the chat, but please know that this is thoroughly explained in the tender documents. Once we publish them, which will happen in April, if I'm not mistaken, you will have the request for tender, a generic explanation like the one that I am giving now. And then in the framework agreement, you will have a full clause explaining the rights and obligations of the parties. One thing that I am going to ask you to do is, if you're interested in Teresa PCP, please follow us, because when we are publishing the tender documents, we will duly inform you. We will also disseminate this. You will be able to download the tender documents, and you will be able to check all the clauses and conditions, including these ones about intellectual property rights. And if you have questions, if you think that something is not aligned, whatever it is, you have the right to ask questions and clarifications, and we can address them and even further modify the tender documents. So please follow this up if Teresa PCP is interesting to you, because we are more than open to your questions, to your request, and to clarify if necessary, okay? So that's another thing. In the last part, what I wanted to explain to you a little bit is the confidentiality aspects of pre-commercial procurement. As you know, we are now conducting the open market consultations, and you can actually find confidentiality in all the phases of a PCP, including the preparatory phases, such as the open market consultation. So you are going to see confidentiality mentioned in all our preparatory documents, but you are going to see also confidentiality disclaimers during the submission of your tender, and during the execution of the contract. So let's see these three different phases, the preparatory phases: open market consultation, submission, and tender execution. In the open market consultation, you know that we need to achieve this difficult, because it's difficult, balance between transparency and confidentiality. In the sense that, of course, everything that is said during this open market consultation, we need to share it with the market with just one goal: to ensure that everybody is on the same level playing field when they submit a tender. So, of course, this is the preparatory phase, but once we are publishing the tender, everybody should have the same information. There cannot be no discrimination because somebody got more information for participating here. That means that if you submit a question to us, we are going to anonymize it, so nobody is going to know who asked, but we have to publish it. We have to give all the information that we can so that the whole market is aware of where are we standing, right? And the reason behind this is that we need to prevent any competitive advantage. Again, this careful balance between confidentiality and transparency. And the goal is to comply with proportionality and non-discrimination. That's why also private or bilateral clarifications are not permitted. Please don't make this difficult for us. Don't try to contact a particular person that you might know in one hospital. If you have a question, please send it via the appropriate channel so that we can address it in a correct and legal manner. Okay, it's highly appreciated. Another thing, questions that fall outside the scope of the open market consultation may not receive detailed responses. On this, I want to tell you a very practical thing, right? We have been receiving many questions. Thanks for that. We really appreciate the interest. And we are publishing the appropriate responses. But sometimes the questions are not extremely clear. I have a request for you and a recommendation as well. If you see your question answered, but it does not fully address what you meant, please don't be afraid to resubmit your question, further clarifying it, okay? We will reply to it again, and we are not going to be mad or anything about it. We actually appreciate that you are following up on that, because what is not clear for you might not be clear for other suppliers. So please, if you see your question answered and it hasn't been properly addressed because we did not understand it in full, send it again, we will check that again. Another important disclaimer: this consultation is not binding and does not give you or us any kind of right. So it's just information that we are gathering from the market that will be duly considered for our tender requirements. What you're doing is actually helping us understand if what we are asking for is feasible and if we need to fine-tune it so that in the end we have the best tender possible and we have the best results possible. So you really are helping us to ensure that we can define a solution that is achievable by the market, and also to propose ideas that we might not have even considered because we just don't know. So that's the idea of the open market consultation. And again, very linked to this balance between confidentiality and transparency. We need to be as transparent as possible, meaning we need to publish the information that we receive. In that lines, please don't make this a little more difficult to us in the sense that do not submit confidential, proprietary, or commercially sensitive information. We are not going to publish if you say that this is confidential, but we will have an issue because we need to be transparent. We will just discard that information. But if you can avoid sending that to us, highly appreciated. The next step in which you will find confidentiality is in the submission of the tender and in the execution of the tender, right? Once we publish the tender documents, you will see that there are actually hard consequences to the breach of confidentiality. In fact, a contract can be terminated if confidentiality is not respected. So I would highly recommend you to check the framework agreement, which is the umbrella contract for the whole PCP, to check your obligations in the sense of confidentiality. Well, to check your obligations and to check our obligations, because of course you are bounded by confidentiality, but so we are. Things that you might find interesting. If the public buyers share confidential information with you about the project, you need to keep it confidential for 4 years. If you share confidential information, or we share confidential information with you in an oral manner, we need to do that by writing in 15 days, okay? Because otherwise, we will try to maintain that as confidential, but we are not legally, nor you, nor us, to keep it confidential. So always, always, always in writing, okay? Of course, if you receive confidential information for the public buyers for the scope of Teresa PCP, do not use it for something else, just for Teresa PCP. If you need to disclose confidential information to your staff, because of course they are working in the project, that's fine. Just make sure that you are sharing that in a need-to-know basis and that your staff is bound to you by a non-disclosure agreement, right? For example, in my contract, I have one of those, so I cannot disclose any confidential information of any project. Just make sure that your staff is also bound by some confidentiality agreements, or otherwise, just make one specifically for this project. And last but not least, confidentiality may cease to apply. So imagine that the public buyers group has shared with you confidential information, and at a certain point, they tell you, no, this is not confidential anymore. You're not bound anymore by the confidentiality obligation. Or, for example, imagine that the public buyer that gave you the confidential information all of a sudden publishes it in their website. It's no longer confidential. And also, we need to be careful about some laws for the European Union of national law that may make confidential aspects not confidential anymore. But we will duly inform you during the execution if that happens. And yes, this is going to be my last slide, just for you to know, when you submit your proposal, you will have to submit a template explaining how do you propose to address the challenge. In that template, we actually have a section where you indicate which parts of your proposal are confidential. One thing that I will repeat in upcoming information sessions once we publish the tender documents. Do not say that your whole proposal is confidential. That's not allowed, okay? You need to indicate in a brief manner which parts, which sections are confidential, and just maybe state this is confidential because if this information is leaked, this will affect my competitive edge over competitors. And give me reasons for that. What I need you to do is not say everything is confidential because, I mean, the name of your company is not confidential. There are aspects that are not confidential. I need to know exactly what is not confidential. And at the end of each of the phases, you will have to submit an end-of-phase report for you to know. That report is where you're going to explain what you have done in each of the phases and the results. So what were your initial assumptions and what was the end result? The whole document is going to be confidential, just per se, but there will be an abstract where you have to explain the project. And that will not be confidential. It will be clearly marked, but for you to know. Also, this is because of course, we are working with the European Commission as well. We need to ensure transparency, so we are publishing at the end of each phase what has happened in each of the phases. But we give you the right to decide what should be published or not. That's the goal of it. And that's all on my side. If you have questions, of course,